This first case sets the tone. A judge trying to balance order and opportunity. Defendant Kyra Rogers faces a theft of service charge, but the real tension is procedural. Will she follow the court's command to find counsel or risk her bond being revoked? Accountability begins with responsibility.
Good morning. You're Kyra Rogers. And Ms. Rogers, this is your initial appearance in cause number 25 BCCR 0976. You're charged with the state jail felony offense of theft of service from June 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
When I had talked to the blood people, they told me that I was going to get a court appointed.
Right, so when you were in custody, we automatically give you a court-appointed lawyer, but once you bond out, what I do is expect you at least to try to hire a lawyer. So I'm going to reset your case for about 30 days to give you some time to see if you can get a lawyer hired.
If not, I can get a court appointed.
Listen to what I'm saying. You have to try to hire a lawyer, okay? If you get a lawyer hired, then you need to bring the reset notice to that lawyer. They'll tell you what to do. If you are unable to hire a lawyer, I want you to talk to at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Okay, step in front of the clerk.
Here, emotions collide with paperwork. Edwania Johnson, a mother tangled between probation and parenthood, stands before the court hoping for leniency and reunification. Her choices are scrutinized not only by the judge but by CPS. The real question, can redemption and rehabilitation coexist when the system demands perfection?
Good morning, you're Marquise Berry. Speak up. And Miss Berry, were you able to get a lawyer hired? That's right, I remember now. Okay. So what this says is that you don't have any complications that would require you not to work with some certain parameters. So you're not on bed rest. For who? Have you tried?
I was working at a disaster group before I had stipulations. And let me go due to the fact that I had all those stipulations.
Okay. All right, so I'm going to have you fill out some paperwork this morning, Ms. Berry, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct. Step in front of the clerk down there. She'll give you that paperwork.
This segment unfolds like a second chance on trial. The judge delivers deferred adjudication across 3 cases, a rare window for Johnson to rewrite her story. Yet beneath the relief lies a warning. One slip, one probation violation, and the dream of a clean record turns into hard time.
Good morning. You're Edwania Johnson? And Ms. Johnson was previously in court, entered pleas of guilty in all 3 of her cases. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Are there any additions or corrections?
I'd just like to address one thing that Mr. Smith had a problem with. It's kind of a law of parties thing on the forgery, I think, and I'll ask my client to clear it up. Now, you were working for a home health care agency, is that correct? And
Answer yes or no, please.
and your client at the time had asked you to dispose of some personal life insurance, is that right?
Yes, and I took them. I misspoke. I meant to say I took the chicks, and I knew that Adrian Hayward was gonna cash them, so I'm just as guilty as him.
So, and she said in here that she's the one who took them.
Yeah.
So I'm
Mr.
okay with
Smith
that.
brought it up, and
Okay.
I wanted
I had an issue.
figure out culpability.
I appreciate that. Yeah, I
And
agree.
they've never caught AJ.
No, I've been hearing that he's incarcerated or whatever, but I haven't been around.
Okay.
Thanks.
Any other issues?
No, Your Honor.
So I would like to know, just so that I know what, if any, conditions, what is the status of children? Where are they? Who are they with?
They're in foster care right now. They wanted Judge Shelton, I think this is his name. He wanted the restrictions of the probation so he'll know how to move forward. But I went to court the 16th for them, and they was trying to dismiss him, but I didn't have paperwork on probation.
Okay.
Um,
What,
Speaking with Deborah's story, that typically, as a condition of the criminal case, sometimes they put some of the, won't abandon and get some of the CPS rules. I didn't see that.
Well, I guess I want to know what the status of, is CPS still involved? Is there a plan in place right now, an emergency?
I spoke with the CPS caseworker, and they wanted to know how these criminal cases were going to resolve. The plan's always been reunification. She's done real well with them, according to her, the caseworker.
So I guess what I'm going to need is, or probation's going to need is, my ruling's going to be that there's no unsupervised visitation unless she's followed through with all of the CPS plan. And so, and that's pretty much what the PSI says, is that their recommendation is no unsupervised contact without authorization from CPS. So if you're doing everything you're supposed to with CPS, and they,
We can go talk to Judge Shelton maybe, or no, is this is fine?
no, I mean, that's as long as she's, but she's gonna have to give her probation officer documentation from CPS, so you can work that out with your probation officer. So mine's gonna be no unsupervised unless, and then if probation gets that information and she's doing her safety plan and everything, then we're gonna be okay with that here also. But they're gonna kind of be the ones that dictate that process, not me.
Just kind of nebulous. A couple conversations with appointed counsel on that, and a couple conversations with the caseworker.
Okay, all right, so Ms.
Get this
John.
done is what they told me, so.
Ms. Johnson, in cause number 24 DCCR 2151, I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings in that case for a period of 6 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 24, DCCR 2152, also find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty. However, I'm again going to follow the agreement that you made with the district attorney and defer all proceedings for 5 years. There is not a fine in that case, and again, you're ordered to follow all of the rules and conditions of probation. One of the rules and conditions is that you have no unsupervised contact with any child, including your own, under the age of 18, unless CPS says that that's part of the plan and that's where they're working. And once they do that, if they do, you have to get that information to probation. So you can't just say, okay, CPS let me do it and I'm going to start seeing them unsupervised, because we won't know that you have that permission from them. Does that make sense?
Yes, ma'am.
So you've got to make sure and go talk to your probation officer, make sure they know everything that's going on. And so part of your probation is that you are required to comply with all the conditions that CPS is imposing. So if there's still any classes you have to do, whatever it is, that's now also part of your probation. Does that make sense? So if you do everything that you're supposed to while you're on these probations, then this is an excellent opportunity, because you don't have the felony convictions on your record. And at the end of the probation, if you do everything that you're supposed to, then the cases will actually be dismissed and you'll never be a convicted felon. The other side to that, though, is that if you violate any condition of probation, you can be brought back into court. You can be found guilty of each of the offenses. In that forgery case, you could be sentenced between 2 years and up to 10 years. And in those injury to a child cases, you could get up to 2 years in a state jail prison. Do you understand? In all of those cases, I'm handing you the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right? Good luck to you, ma'am.
Now the focus shifts to Ryan Eric January, charged with solicitation of prostitution. What appears routine takes a surprising turn when the judge strips away a sex offender clause and replaces it with something symbolic: education. Justice here isn't just punitive, it's about transformation through accountability and opportunity.
Sir, you're Ryan Eric January. Speak up, please. And Mr. January, in cause number 25 DCCR 0370, was previously in court, entered a plea of guilty to the the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have state house.
Any additions or corrections?
Nothing but
So I guess I had a question. I did not realize if we do this on all or if this, but it's showing a requirement to be on the sex offender caseload. But this is not that type of offense. It's not registrable. And so I don't believe that we have been doing those or,
We have.
I'm sorry. Okay. Yeah, I want to rescind that unless there's some reason specifically in this case that there's different you can get with me. Another thing, so I'll take that out of the orders at this time, and then if there's any issues, then we'll make sure everybody knows about it and we'll get back together. The other thing, Mr. January, that is I'm going to order as a condition of your probation is that you get your GED. It is very important to me. It should be important to you. It will help you do better, get better jobs in your life, and so it's going to now be a condition of your probation that you start that process within 30 days of today, okay? So you talk to probation, they'll let you know how to get started on that, and you need to get started on it, complete it, and that'll be at least a good positive thing that happens out of all of this. So again, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement, defer all proceedings, and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of those rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete the probation, the case will actually be dismissed. You'll never have a conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sentenced to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's going to call you up to your desk when she's ready to go over all of your paperwork. Good luck to you, sir.
Across these 4 cases, the courtroom painted a vivid portrait of how justice breathes, firm but flexible, procedural yet profoundly human. Each defendant stood under the same fluorescent lights, yet their journeys revealed vastly different intersections of law, struggle, and second chances. Kyra Rogers' moment was simple but defining. Charged with a theft of service felony, she wasn't yet fighting guilt or innocence, she was fighting inertia. The judge's insistence that she try to hire counsel reminded everyone that the justice system doesn't chase you, you must meet it halfway. A misstep in responsibility can echo louder than the original crime. Then came Edwania Johnson, whose situation fused criminal accountability with maternal heartbreak. Her crimes, forgery and injury to a child, carried deep personal and social weight. Yet within that, the judge saw progress, compliance with CPS, steady effort, and a path toward reunification. This wasn't just sentencing, it was soul surgery. The courtroom became less about punishment and more about restoration, a reminder that mercy isn't weakness when it's tethered to structure. Johnson's deferred adjudications were the court's gamble on hope, 3 chances to rebuild without a felony record. But the terms were razor sharp: full cooperation, total honesty, and flawless probation conduct. Her story underscores the truth that justice offers redemption, but only to those who work for it. Finally, Ryan Eric January's case pulled the lens wider. His solicitation charge, though low-level, carried potential stigma, yet the judge pivoted toward education, making the GED requirement the cornerstone of rehabilitation. It wasn't about shame, it was about skill, replacing a label with a ladder. Together, these hearings reveal a justice system wrestling with humanity. Judges are not just arbiters of law, but engineers of possibility. From legal threats to life lessons, the courtroom remains a place where futures hang in the balance, often by a thread of effort, empathy, or sheer will. If you found these cases as shocking and insightful as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns where law meets life and every decision tells a story.